Harrell,
Here.
Senator Douglas,
Present.
Senator Neal, Senator Nemus, Senator Thomas, Representative Blanton, Representative Burke,
Here.
Representative Fleming, Representative Lockett,
Here.
Representative Riley,
Here.
Representative Sharp,
Present.
Representative Stevenson, Vice Chair Howell, Co-Chair Storm,
Here.
and Co-Chair Bowling.
I'm here.
Thank you.
We have a quorum. We're duly constituted to do business. Entertain a motion to approve the minutes from September 14th of
Motion.
23. We have a motion and a second. All in favor say aye.
Aye.
Any opposed? Those minutes are adopted. At this point, Co-Chair, Co-Chair Bowling, do you have any announcements or anything?
I do not.
As I said, the agenda is very robust, some heavy topics, so Mr. Secretary, if you would introduce yourself and your guest, and you may proceed.
Kerry Harvey, I'm the Secretary of the Justice and Public Safety Cabinet. I have several folks with me here today that I'll introduce. Vicki Reed, the Commissioner of the Department of Juvenile Justice. And if these folks will just stand up so you can see them when I introduce them. James Sweat, who is the Executive Director of the Department of the Office of Detention at DJJ. Larry Chandler, who is the Assistant Executive Director of the Office of Detention at DJJ. And we also have the leadership of the Internal Investigations Branch at the Justice and Public Safety Cabinet, Mr. Ed Jewell and Mr. Steve Potts. And so I thought if this suits you, Mr. Chairman, I know you had asked for a number of topics to be addressed. I thought I would sort of act as the traffic cop maybe and introduce the topic and who will have to address those, and then let them give their presentation. You, of course, can ask any questions that you might want.
That sounds fine. Thank you.
Okay. First, you had asked about, and this probably shouldn't take too long, but you'd ask about the status of the Department Compliance Division's review of the events that led up to the issues at the Adair Detention Facility last November. And Commissioner Reed will give you an update about that. I would remind the committee that our Compliance Division within the department actually did not exist when those events occurred last November. The Compliance Division was created by the reorganization that we requested and that the General Assembly approved in Senate Bill 162. So, Commissioner?
Yes, and mine will be quick. They are reviewing the events of the riot. The investigation is not yet complete, but it's very close to being finalized. And as soon as that happens, we'll be happy to provide that report to co-chairs Storm and Bowling and answer any questions once you've had a chance to review it. And I'll also state that we're aware that the state police continue to have an open investigation as well.
Can we proceed with
Let me ask you just one question.
Sure.
Does that, do you have an update regarding the Kentucky ACLU's request regarding the investigation into the Adair County Detention Center?
No, sir, I don't. I don't know a lot about that. If we're talking about the same thing, I think the ACLU had made some request to the U.S. Department of Justice. Is that what you're talking about?
I thought it was directly to you all as opposed to the Department of Justice, but perhaps it was to the Department of
I
Justice.
think that's, let me get,
Department of Justice.
yeah. And so that's, having been in the Department of Justice, they tell you what they're going to tell you when they're going to tell you. So they haven't told us yet. So
no update then?
no, not
Thank
on
you.
that. No. Next, Mr. Chairman, you'd asked for information concerning the use of OC spray in juvenile facilities. And we have, and you specifically asked to hear, I think, from Larry Chandler. And we have Mr. Chandler here and also Mr. Sweat, who I previously introduced. And I would like to, just as a little background of this topic say that, as I mentioned earlier, we did reorganize the department last spring. That reorganization was approved by the General Assembly in Senate Bill 162. I think the reorganization has led to significant improvements in our operation. In addition to completing or creating the compliance division, we changed the way that we manage detention facilities in the system. Previously, the pre-disposition detention was managed by the same management chain that also had responsibility for other facilities such as youth development centers and group homes, and those responsibilities were divided along geographical lines. And there were also, I think, 3 or 4 levels of management between a building superintendent and the department commissioner. In looking at this, it's apparent that the issues and the challenges of managing predisposition detention centers are different. They're unique when compared to a group home or a post-disposition facility. So our reorganization created an Office of Detention, and that allowed us, first of all, to streamline the reporting chain. Mr. Sweat, who is the executive director of that office, reports directly to the commissioner, and the superintendents report directly to him. We also were able to focus more sharply in that manner on the challenges facing the detention facilities. And we were able, at least in my judgment, to attract 2 uniquely qualified individuals to run that office. And I will, for what it's worth, I think they're doing a really remarkable job, and I think they're making great improvements. James Sweat, who is the executive director of that office, has previous experience working with juveniles and has over 40 years of experience in the corrections department. Larry Chandler, who is the assistant executive director of the Office of Detention, has enormous experience in running secure facilities. He's the only person who has actually been the warden of 6 different adult correctional facilities in Kentucky. I think it's fair to say that Mr. Chandler has probably trained most of the wardens that we have in Kentucky now, and I can tell you we have a superb group of wardens in the Department of Corrections. And so these gentlemen bring enormous skill and experience to this very challenging task. In terms of OC spray in particular, the department made a decision that we would deploy OC spray last January, and then that the use of OC spray in juvenile facilities was enacted and mandated by the legislature in Senate Bill 162. It is not a perfect tool. Like any tool, it can be used properly or improperly. But the last thing I'll say, and I think this is a significant data point that I've learned from Mr. Sweat and Mr. Chandler, they tell me that in the 6-month period prior to the deployment of OC spray in these facilities, that we had 29 instances where one of our staff members was assaulted by a youth. In the 6 months after this deployment, there have been only 8 such instances. So I think that you can make of that what you will, but I think that's a very significant data point. So I'd ask Mr. Sweat and Mr. Chandler to come up and address the committee.
Gentlemen, please introduce yourselves for the record.
Yes, my name is James Sweat. I'm director of the Office of Detention for DJJ.
Larry Chandler, Deputy Director of Detention for DJJ.
As the Secretary has already told you who we were, just like to reiterate some of our like he said, we have over 41 years of corrections experience. I also had 4 years with Juvenile detention under Secretary Lewis back in 1995. So I am familiar with the system. We have been given the task of implementing all of the mandates that the legislators have put in place with DJJ. And Mr. Chandler will go over in detail about OC spray, but also it was mandated the STG program, CERT team. As you see, Mr. Chandler, they also had us put our people in uniform, and he's wearing one of our uniforms today. Cell entry. We also have entered into MOUs with local fire department and law enforcement, and also we are in the process of implementing something with mental health program for the kids. So at this point, we'll let Mr. Chandler go in detail about OC spray.
Well, we thought it'd be a little useful for you to understand my background and my experience with chemical agents in general. When I started my career back in the early 80s, I got involved with CERT team operations, emergency preparedness. And one of the training recommendations and prerequisites back then that you had to be exposed to CN. And back in those days, they put you in a little shed with 2 doors, and you put a gas mask on, walked in to a shed full of CN and took your gas mask off, and you had to survive for a minute. So that was my start and introduction to chemical agents. And over the years, you know, we've back in, I think, in the late 80s, they decided, because of the violence, particularly at Eddyville, to allow staff to start carrying chemical agents. And back in those days, it was mace. I remember after going to a disturbance at Eddyville on a critical incident review, I was walking through Cell House 3, where all the disciplinary action and all the worst of the worst were housed. And as I walked by a cell, an inmate reached out and grabbed me by the arm, and the lieutenant I was with pulled his mace out, and he sprayed the inmates, sprayed me, and sprayed everybody in the neighborhood. So, and over the years, we've seen that it can be a useful tool. It can be a bad tool with bad training, inadequate training, and it can be, even with the best intentions in the world, it can be some unintended consequences. So when I come to DJJ back in January, and the secretary wanted to get ahead of the legislative mandates and asked me to let's get OC's training started, we knew that we had to do 3 things. We knew we had to. This was brand new for everybody in the Department of Juvenile Justice. We knew we had to procure the product, and if you remember back at the end of the COVID period, at all the supply chain issues that we had, so we bought the product. We had to develop a policy, and that required some work. We developed a policy and post orders to make sure that we had the checks and balances in place for everybody to understand when and how and why to use OC spray. And then we had to develop the training. We leaned and borrowed on our friends over at Kentucky DOC on the adult side. They trained everybody in our initial training at Warren County, at Fayette County, at Adair County, and at Campbell County. And then our academy went with them and learned how to do the training, and they took over the training after that. By the time, I think by mid-May, we had everybody trained in our high detention facilities on OC spray. Now, the bad news is that we obviously had some misuse of OC spray. and almost right off the bat, in spite of the fact that we put in some checks and balances. Some of those checks and balances was to, when OC spray was distributed in the institution, we weighed it when it left, and we weighed it when we come back, when it was returned. And there were some other checks and balances in the policies and the post orders that we developed at that time. When in almost every incident that our internal investigation team looked at, and we looked at, Mr. Sweat and I looked at, we took disciplinary action. We dismissed some what we thought were very good people, but we think. You know, and if you have a tool like this, you know it's a valuable tool, and you want staff to use it. You don't want staff to be afraid of it, but you don't want them to overuse it. You don't want them to misuse it. So I think probably since early June, July, a great deal of our time has been spent looking at every time that we deploy OC in an institution. I think after Secretary Harvey's introduction, I probably ought to shut up now. And
Let me ask you a question.
Sure.
Can you explain to the committee the training process that you utilized to train individuals to
Yes.
use OC spray?
it's done in our academy in Jefferson County, and everybody's exposed to OC spray. Everybody's, we go over the policy, we go over the post order, we go over the checks and balances. Everybody who has not been exposed to OC spray gets exposed to it, so they know what the effects are. Does that answer your question, Senator?
If that's your response.
Yes.
Let me ask you this. You mentioned policies. Are the policies that are utilized to use this as a defensive tactic or as punishment?
No, it's a defense tactic. It's a defense tactic.
Senator Carroll has a question, I believe.
Thank you, Mr. Chairman, and gentlemen, thank you for being here. Along those lines with the training, what exactly is the language in the policy on when to use it? Can it be used as a preventive measure to prevent an attack if one is perceived,
Yes.
or at what point does it become a defensive tool, and is it allowed at some point as a to prevent an incident from occurring?
You know, the language of the policy says in defense, use the least force possible, and it's in defense of other juveniles, to prevent major property damage, and to prevent assault on staff.
Okay, and as you all have gone through this, and normally you have to, when you implement new policies within any type of law enforcement related agency, corrections, whatever, it takes a while for the staff to understand what the parameters are of a policy, because it can be interpreted in many different ways. How have you all, as far as each case that you've looked at, how have you distributed information, or how have you tried to clarify what the policy actually says and what the parameters are?
It might be useful too to go back. You know, when I started with DJJ in December, one of my first job was to go around to all the detention facilities and all the youth development centers and look at the security of those institutions. You know, I went to some detention facilities with a 60% vacancy rating. You know, people working 12, 14 hours a day, 7 days a week. There was a lot of frustration. We knew that going in using this tool. So, you know, we were careful in implementing the policy. We had, before we even deployed it, we had a meeting with every superintendent about here's what's expected of it and here's what we expect you to do. In my tour around the state, I talked personally with every facility manager on the YDC side and the detention side and told them what we expected. Afterwards, what we've done, is every deployment of OC gets reviewed by us, by the Internal Investigating Bureau, and we've asked every facility manager, when you have a deployment, whether you think it's good or bad, let's do a debriefing with the staff. Could you do other things? Could there be some other de-escalation? Could you intervene some other way? So those are some of the things that we've done since we've implemented OC spray.
I don't say that to be critical. It stands to reason when you look at the struggles that we've had within DJJ facilities over the past year or two. There is some apprehension on safety. So
Sure.
I think the expectation that there are going to be some incidents where perhaps it was used too soon, that's going to happen. And I think we have to be careful not to overreact to that. And it will take a while for staff in each facility, for you all to standardize throughout each facility what the expectations are. You can put it on paper all day, but until they actually review incidents that have taken place, then that's when they'll start really understanding how to use that. So and I think it's also important to understand that there are staff within these facilities, which could be nursing, it could be whatever, that might have a different perspective on how
Absolutely.
on the propriety, the proper use
Absolutely.
of this tool, and we have to understand that we can't take away if it's somebody getting hit with pepper spray or someone getting an arm broken or a nose broken from a punch. That's why the pepper spray is there. And if it rises to a level where that risk of a fight breaking out or there being physical injury, that's the point of having pepper spray.
Yeah.
So, and that takes a while for, I think, when law enforcement started using it, it took a while for the public to understand that. So, and I think as a body, we need to be careful about accusations, but we need to, we obviously don't want anyone using it just as a punitive measure, but we have to remember this is new, and it's going to take a while to set those boundaries and not jump too soon to judgment on this and really look at each situation. And I hope that at some point we can see some of these reports and understand, when are they actually using it, where are the problems.
To your point, Senator, I'll give you an example. This happened in Warren County shortly after we deployed OC spray. A lady was trained in OC spray, had OC spray on her duty belt, and was trying to talk to a juvenile who was in his cell and get him to calm down. Well, he jumped out and punched her in the mouth 2 or 3 times, and a couple of staff members come to her aid and were wrestling with the kid in the cell and were losing control. And one of the officers asked her to bring the OC spray in, and she did, and she sprayed the juvenile and the officer. So there's some unintended consequences. I mean, even though it doesn't prevent all assaults, but it's a good deterrent effect, I think.
Mr. Chairman, if I might.
Go ahead, yes.
Can you give a couple examples of improper uses where you all have held someone accountable or perhaps even terminated?
Yes, we, almost immediately at Adair County, we had a deployment of OC spray that was clearly wrong. We issued a disciplinary action. I think it was
10 days.
Several days disciplinary action. And a month later, she did it again, so we dismissed her. Another incident I remember in Campbell County, we had a captain we thought a lot of, and he clearly misused OC spray, and we were preparing disciplinary action for him, and he resigned before he faced disciplinary action. And I don't have the number of people that we've disciplined. My guess would be close to a dozen, would you say, that have deployed OSP, and we didn't think it was quite proper. Our internal investigative branch, they look at all the OC sprays. They do a thorough investigation, and certainly we take their lead as well.
And sir, I do appreciate that, but that doesn't answer my question. What are the situations to where it was determined to be improper, where people were terminated or disciplined? Was it used as
You want to answer that?
was it used to control someone without any threat, or what were the situations?
We had a situation in Campbell County where the captain just walked in and sprayed, for no reason. And we were in the process of dismissing him. He got frustrated with one of our clients, and he just walked in and sprayed her. And we terminated him. And like Mr. Chandler said, he quit before we could terminate him. But one thing, going back to something else, also it needs to be known that every OC spray is videoed. So we can go back and look at the video and look at why it was deployed, if it was done right. We view those after every deployment. And we also make those videos available for the investigation branch. They view it too. So we're not only viewing it ourselves, somebody else is also viewing it. And we also use those videos as tools to teach the staff the right way and the wrong way to do it. So we have that to go back and point out, this is what you should have done. You could have done this or done that without deploying OC spray. So by videoing all of them, we have really used those as tools to teach. And let me further to say, we have been so short-staffed. We have to understand that almost everybody that is employed is on probation. They're on probation because we just went through training. Like Mr. Chandler said, we're in the process of teaching everyone these new things that we are putting in place, and it's a process. It's going to take a little time to get all of it processed. For example, Campbell County, almost everybody there is on probation because we had to hire a whole new staff for that facility. We are teaching them how to use these different things that will help keep the kids safe and staff safe. So to answer your question, that's one area. And then we had another situation where a kid just smarted off at someone and they just sprayed them. That's not appropriate. And they was disciplinary action was taken against that person also. So we take it serious, very serious, and we want it to be used correctly. Did that answer your question?
Yes, sir. Thank you. Thank you both.
Senator Douglas has a
I
question.
think too, it's important to remember, with the staff shortages that we've had and coming off of 2 years of COVID and the frustration that staff have, I think sometimes frustration override the good judgment and all the training we can provide, and unfortunately we have to deal with that.
Senator Douglas.
Thank you, Mr. Co-Chair. I just wanted to address something that was said in the very beginning, since we do have our public watching this as well, and they may not understand some of the things that we say as easily as some of us do, since we're here all the time. A statement was made earlier that the legislation mandated the use of OCs, and we know what that means, but those who are watching do not. What the legislation did is that it mandated that these can be used. We do not mandate the use of these particular chemicals. I just wanted to say that, Mr. Co-Chair, to clear up any misunderstandings.
Any further questions? I did have one follow-up related to Senator Carroll's question. The incidents that you're referring to, are there records kept? And I know you mentioned videos, but what happens if I think some facilities, there's not cameras every inch of the place. So what would happen if there's a discharge in a laundry room, perhaps, or something like that?
Well, a report would be done if a youth and a worker was in the laundry room, and that's basically the only place there are not cameras. We have cameras everywhere else. When we bring the OC back, we would weigh it, and also because if it was deployed in the laundry room, there would have to be a cleanup, so it would have to be a report done on it. Anytime OC spray is used, a report is done on it, and again, it would also be sent to IB&B for investigation. So there will be records at the facility, and they would have records of the deployment.
We have a follow-up.
Yeah.
Co-chair.
One quick question. On that reporting, I know you said you get internal investigations involved. What is the chain of command on that reporting? And then what is the timeline on that chain of command?
Okay, deployment, once OC is deployed, IB is called immediately. It's reported by either the assistant superintendent or manager or the manager. It's reported to IB. They get a call.
Okay. And then, where does that go? Is that just with internal investigations? Does the Justice Cabinet as a whole know about it at that point?
Well,
and this may be a question for Secretary Harvey.
Well, every deployment, I get a call, or we get a call.
Mm-hmm.
I get an email from the facility saying OC was deployed immediately.
Okay. And my reason for the question is, especially like on the timeline, we've all recently read what happened in Campbell County, and that, some actions were being taken, sexual assault by an employee. And while everybody at the Campbell County facility seemed to know what was going on, it seems the cabinet and people that could take action did not find out until June, from my understanding. And so I guess I do have some concerns, just making sure this reporting is getting to the right channels, to people that can take actionable, can take actions on it immediately, so that somebody's not getting, misusing OC spray for 3 weeks or a month and a half before it finally gets addressed.
No, that's not going to happen.
Okay.
And also, I started May the 8th, and it's been reported everywhere, over the news and everywhere about Campbell County. And the staff that was in charge there, as soon as I got there, within 2 weeks, I demoted him. And 2 weeks after that, I fired him. I can only fix what I know about. The reports were not getting to me. Once the reports got to me, I took steps to rectify it.
And that was the point of my question.
Yes.
The reports were not getting to you.
Right. But it was due to the staff that were in place at that facility at the time.
Understood.
And as soon as we recognized that they were not doing their job, then we took necessary steps to change that. And it wasn't being reported by anybody in writing. Once we got that information in writing, we took steps to make those changes.
That prompted a question that I have. You mentioned in writing, but what about the agency's internal hotline where staff were calling and reporting this to the hotline? Who answers that hotline, and are there records kept as to those calls?
Yes, IB they keep those records.
And is it your understanding, your testimony here today before this committee, that the agency did not receive internal hotline calls regarding the Campbell County incident?
That was my understanding.
I think that's all the questions we have for you two. Thank you.
Mr. Chairman, on your last point, just to make sure that there's no confusion, we've got our internal investigations branch folks here who can tell you what reports they got, what they didn't get. I think that's our next topic, because there could be reporting that would go directly to them that may not go through the department. And so they'll discuss that. I guess I would say about the OC spray, you know, obviously, and I think you can see that the training is serious. There's accountability when it's misused. We don't want it to ever be misused. But I think we made the right decision to deploy OC spray when we decided to do that in January. I think the legislature made the right decision in Senate Bill 162. I would associate myself completely with Senator Carroll's remarks on this topic. I think what he said is correct. And I would just remind you that when OC is deployed, and I think this is sometimes easy to forget when we discuss it, you know, when you need to deploy OC spray, in most of the instances are where there is an assault going on, or an assault is obviously imminent. And in those cases, it's not a matter of deploying OC spray or nothing, you know, because if you have an assault going on, something's got to happen to interrupt that process. So if you don't have OC spray, what you're going to be left with is physical force. And we can all have our own opinion about this, about whether it's better to use physical force or some tool that may allow you to prevent contact with that juvenile. I know what I think, but we can all have our own opinion about it. But I just wouldn't want anybody to think that, well, it's either OC spray or nothing. And I would also say, this is just my opinion, I'm speaking only for me. I don't think it's right if we have staff members who are being assaulted by some juvenile. We're keeping some pretty tough juveniles. You know, we have, I think, 23 juveniles in detention who are in detention for murder or complicity to murder. So these are some pretty tough juveniles. I don't think it's right for us to expect our staff to be assaulted by a juvenile who might be 40 years younger and 40 pounds heavier than they are and have absolutely nothing to defend themselves with. But again, that's something that we can everybody has their own subjective opinion of that. It is our job, and we take it seriously. And I know Mr. Sweat and Mr. Chandler take it seriously to make sure that our people have the best training we can give them. And when they misuse this tool, there's accountability. And I know that we have even just recently gone back and reiterated to our superintendents that every time OC spray is deployed, it has to be reported. The Internal Investigations Branch has to have an opportunity to investigate that. And I think this is like, as it's been mentioned, like any new tools, as we gain more experience, our people will be better at it. But again, I think it is a very valuable tool. I think it has played a role in the very significant reductions in physical assaults on our staff. And you know, when our staff is assaulted, it's not just that our staff that's endangered. That juvenile is endangered too. Because if somebody's punching you in the face, you're probably going to do whatever you have to do to defend yourself at that moment. And if we can deter that, and if we can avoid that physical altercation, in my judgment, that's good. So I just wanted to make those points.
Senator Carroll has a question.
Sure.
Mr. Secretary, do you all have any numbers since OC spray was distributed on assaults? I mean, how many have we had, and what percent down are they from the previous year, or any data?
Yeah, the information I was given, and Larry, you want to give? Did Larry C still here? Can you talk about? How many? Yeah. I'll let Larry answer just what the experience has been in terms of the level of assaults before and after OC spray was deployed.
We went back 6 months before the OC spray was deployed and looked at the number of assaults, and I think there were 29 assaults throughout the detention facilities. This doesn't count the youth development centers. and measured that against 6 months after we deployed OC spray, then there were 8 assaults. So that's and that was similar to what happened in the Department of Corrections on the adult side. After OC, we started carrying OC in that department. The assaults, and I don't remember the numbers, I'm sorry, but the assaults on staff fell off dramatically.
Thank you.
Okay. I think the next topic, Mr. Chairman, that you wanted to hear information on was concerned the training, reporting, and investigation of allegations of sexual misconduct at the juvenile facilities. And we will have Mr. Jewell and Mr. Potts speak about that. And Commissioner Reed will speak about the training, and all will be available to answer your questions. I think a little bit of historical context may be helpful here. I asked our general counsel to review the Internal Investigations Branch records of, I think we went back to 2015, of incidents where there was some sexual misconduct alleged against DJJ staff, and she has done that. And she found that since 2015, IIB investigated 55 reports against staff classified as sexual activity. Now, that's not necessarily some sort of contact offense. That would include sexual harassment or inappropriate sexual banter, that sort of thing. Of those 55 reports, 6 of them were substantiated since 2015. In 2015, there were 15 reports, 0 substantiations. In 16, 8 reports, 1 substantiation. In 18, 7 reports, 0 substantiations. 2019, 7 reports, 1 substantiation. In 20, there were 6 reports, no substantiations. 21, 4 reports, 2 substantiations. 22, 1 report, no substantiations. And through July or August of this year, I think 4 reports and 1 substantiation. So there, every time you have a case of this, it is obviously unacceptable, terrible. It cannot happen, and it is up to us to be as diligent as we can be to prevent it from happening, from taking every remedial measure that is apparent if something like this happens to prevent further occurrences. But we also have investigators who I think do a very good job of looking into this. And I would just, the Internal Investigations Branch is not part of the Department of Juvenile Justice. They're independent. They're housed in the cabinet. They are, I think, all merit employees. There are no political appointees. And I believe that all of them, there's 7 or 8 of them, I think they're all former law enforcement officers. So they're experienced, they're good at what they do, and they take it very seriously. And in all of the IIB reports that I've reviewed since I've been in this job, I mean, they're obviously very thorough. Again, that when these things happen, it's completely unacceptable. But there are times that it does happen, not just here, but across the country. Nationally, the United States Department of Justice, the Bureau of Justice Statistics, compiles reports from states that relate to sexual victimization of juveniles who are in state custody. The most recent data that DOJ released covered the period 2013 to 2018, and it indicates that 499 substantiated reports of sexual victimization perpetrated by staff of juvenile facilities against juveniles. So obviously this is this is a serious issue. This is unacceptable conduct when it happens, and it's conduct that happens on occasion throughout the country. And I know every state Department of Juvenile Justice deals with this, maybe in different ways, but I know every state takes this seriously. So I think at this point, I'll ask Commissioner Reed to come up and explain the training that our people receive, and then our internal investigations branch will be able to tell you what they do to investigate these cases and answer any questions you have about that.
Yeah. Before she begins, Representative Lockett had a question.
Yes, thank you, Mr. Chairman. My question actually revolved around the internal investigation, so I will hold off until that testimony. Thank you.
Senator Thomas had a question.
Secretary Harvey, we've heard a lot about the number of incidents of the use of OC spray, and I've been trying to get an idea of what it is. I understand it's some kind of pepper spray. Is that a general?
It's pepper
description?
spray.
Yeah, okay.
Right. I mean, I think you can probably buy it on Amazon. So.
What I haven't heard from you is in those uses, the 29 uses prior, the 8 uses since, what's been the harm to the offender that's been incarcerated in this use? I mean, are we talking about the need for surgery? Are we talking about life-threatening injuries? Well, I haven't heard you talk about it after you used it. What's happened to those offenders?
Well, I think part of the policy and part of the training is to make sure they get proper attention, proper medical attention. But it is my understanding that in every case, it's obviously an irritant to the eyes and to the face. It stops you from what you're doing. But I'm not aware that there's been any juvenile who has had any sort of serious reaction or required hospitalization or required, that there were any lasting effects. Now, I want to. That's true. Is that right? So it's, we make sure that once the incident is completed, that they're decontaminated, I guess is the technical word, but I'm not aware that there have been any instance where juveniles had any sort of long-term or really even intermediate-term effects.
I mean, I just think that's an important question
It is.
and fact to be asked, as we make these inquiries.
I agree with you. I think that is important, and it brings to mind, I am aware because I think this just happens in the last 2, 3, 4 months. The U.S. Department of Justice, I believe, indicted a former DJJ staff member for an incident that occurred in 2019. I don't know all the facts of that. That was a previous administration. You all may, I assume, you ask them the same questions you've asked us, but in that case, there was some sort of altercation, and the youth ended up with a broken arm. And now you have that staff member who's been indicted for that. So that just goes to the point I tried to make earlier. When you have these situations, it's not use OC spray or use nothing. It's use OC spray or have a physical altercation. But that is an important question. There's been no case where there's been any lasting effects from the deployment of pepper spray.
Senator Douglas.
Thank you, Mr. Co-Chair. Mr. Secretary, maybe you can help me with a little bit with this question. And I just want to make sure that we on the committee and everyone else listening has a feel for the environment around which you and your staff have to operate. With that being the case, this is really not to justify or okay anything, but if you could you give us any idea of reports or statistics that are kept regarding youth sexual victimization of your staff or other offenders who are incarcerated?
Commissioner Reed probably can give you a better answer than me.
Okay.
Right. We participate in PREA, and for the public, the Prison Rape Elimination Act, and we're required to keep all those statistics. I don't have them with me today, but we can provide those.
Would you please?
Yes.
I'd like to see those. Thank you,
Yes.
Mr. Co-Chair.
Okay. Go ahead.
And I'll continue with discussing PREA because we are a participating state in that. And we are required because of that to do some extensive training. Each facility has a PREA coordinator, and they teach a 2-hour component during a new staff person's pre-service training. The national standards for PREA are explained, as well as DJJ zero tolerance regarding sexual abuse or misconduct. And we also make it clear that even among the youth, there's no consensual conduct in detention, that any is inappropriate, even if it's two 15-year-olds, whatever. So not to be part of that. And then a refresher course is given to all staff annually on that. We have to document and get that for our PREA certification. We also, as you all know, we have our in-service academy, and there are several components that also touch on this. IIB, which you'll be hearing from in a minute, teaches a component which explains their duties and responsibilities, the PREA and signs of grooming behavior. There's a 1.5-hour component on legal issues. The teaching objectives here are for staff to understand the importance of following policy and how the failure to do so will result in discipline and legal proceedings against them. The consequences of negligent, excessive, or abusive conduct is explained, and we also include here the implications of using social media inappropriately. There's a 2-hour component on ethical practices. It relates to their job as youth workers, as an employee of the state of Kentucky and the Department of Juvenile Justice. And here the duty to report requirements are covered during this session. Another hour is spent on specific components on sexual harassment and anti-harassment, so they are familiar with the policies, the definitions, procedures, prohibited behavior, and the investigative process regarding anti-harassment. 3.5 hours are spent on abuse and neglect reporting module. This includes familiarity with our consent decree and DJJ's relationship with IIB, familiarity with investigative findings and the standard of proof needed in investigations, and familiarity with the DJJ hotline for youth and how to appropriately respond to youth who ask to use that. There's another 2-hour course on youth grievance and service complaints, sort of follows up from the one I just mentioned, so staff are aware of the importance of this protection and do not impede any youth's desire to file a grievance or complaint. And youth are explained this during the intake process. They are shown the form. They are given the hotline number. All of our facilities have posters up that with the kids that explain PREA and have the number on that prominently displayed in our facilities. And finally, a 2-hour component on helping relationships. And the goal of this is for new staff to have an understanding of the establishment of healthy boundaries and forming therapeutic relationships with the youth, and to help decipher the difference between what is and is not healthy behavior. So I feel like we have a pretty good handle on our training, and I'm happy to answer any other questions.
I have a question regarding Campbell County. Can you give us a status update as to whether or not males and females are being accepted there, and whether or not you have any sort of updates at all regarding that facility?
Can I address that, Mr. Chairman? Because we do have some plans in the works there, if you'd like to hear about them.
Sure.
I think, as you all know, back, I don't remember the dates, but we moved the girls from Campbell to Boyd. And we did that. That was based on the recommendation of Mr. Sweat and Mr. Chandler. They're here. If you would like to inquire of them about why they made those recommendations, they'd be happy to answer those questions. But basically what they told the commissioner and told me was that, as they've said here today, we had a very inexperienced staff. We did not have solid leadership. They didn't think the young ladies were getting what they needed, and so they were moved to Boyd. They report that since that move has been made, that the circumstances with the girls are much better, because we do have more staff in Boyd and a more experienced staff. And they claim that they tell me that the move has been a positive move, that things are better for the girls. So since that time, we have continued to try to build staff in Campbell County. As you all know, as we've reported many times, and I think we report to the legislature, I think on a monthly basis, what our staffing is. We have been able to slowly build staff in Campbell County. It's not been as fast as in most of our other facilities because of the very hot labor market in northern Kentucky. And we were able, a few weeks ago, to hire a new superintendent who I know our managers are very pleased with. So the plan is on or about a month from now, a little less than a month from now, that we're going to start housing lower level boys in Campbell. So we want to make sure we take the time to get our new staff trained. And I think that will, again, I think we're shooting for on or about November 1st to start housing lower level boys in Campbell.
Any questions? All right, we have another presentation at this point. If you have any finishing remarks that you'd like to summarize very briefly.
Would you like to hear from our internal investigations folks?
If they can do it relatively quickly, we
Okay.
have another presentation.
Well, that's completely up to you.
No, if they would like to come up, yeah, that'd be great. They're here.
Good afternoon.
Good afternoon. Just identify yourselves once you take a seat, please.
Yes, sir. My name is Edward Jewell. I'm the manager of IIB Internal Investigations Branch, and this is my supervisor, Stephen Potts. Understand you guys we're short on time, so I'll be brief, but feel free to ask any questions.
Thank you.
Just briefly, we are non-merit employees, or we are merit employees, I'm sorry, merit. We both have been within the Internal Investigations Branch for 35 years combined. So we've seen numerous governors and secretaries. We've worked for handfuls of secretaries. We appreciate the opportunity to do this job. It's very important. Our office has a very important job of investigating abuse and neglect of juveniles. Quite simply, that's it. We have a great system of doing intakes, processing those. Anybody that calls in, we record those and we process them for investigation. We can answer any questions that you have. We can't investigate things we don't know about. We do review all OC sprays. It took a while at first for them to get those out to us, but after a while, we were able to catch up. I don't know what you want to hear from us necessarily, so it's a little nervous. But
I think Representative Lockett has a question.
Yes, thank you, Mr. Chair. My question goes back to in the previous testimony, some of the numbers that were spoken about in terms of investigations. 6 out of 55 investigations, 6 were found credible. 1 out of 8 on a particular year, 1 out of 7, 2 out of 4. Can you describe the process by which you investigate sexual misconduct allegations, and why a particular year there were 55 allegations?
That 55 is a collective over those years.
Okay.
The 55 is a collective over those years. So then he gave the individual statistics for each year, which was the
Subsequently,
breakdown.
okay.
Yeah, so the 8 would have been 1 year's worth of allegations of inappropriate sexual activity, and one of those would have been substantiated during that year.
Okay. So can you describe the process by which when you get a complaint in, what happens after that?
I can, yes, sir. So when we get a complaint, we will process that complaint. We have a hotline that anybody can call into our office. That hotline is in every facility. The number is posted at every facility. Staff can call. Any resident can call. Any witness to any type of allegation can call us. We take anonymous phone calls. We take letters. Any type of form of communication we take. But there is a hotline that comes right into our office. We monitor that hotline 24/7. We have a staff that will be on duty after hours to monitor it, to make sure whenever a call comes in, it provides us with an email alert. We're able to, each one of us gets that email alert. We can listen to the voice message. We type those into our database. We have a very profound, efficient, and state-of-the-art database that we just recently got. What year was that?
2021.
2021. So we'll type that allegation into a database. We will review the complaint, and if it meets one of our 14 special incidences, we will then assign it to an investigator. An investigator who is trained in sexual assault, sexual abuse. We keep our training up on that. Like the Secretary said before, Everybody has got prior investigative experience, most of which law enforcement. I come from a homicide and sexual abuse, sexual assault background. So we take those matters very, they're very important. We'll send an investigator or two to collect evidence, to speak to any witnesses or any offenders. If there's any indication that it could be a criminal action, we will notify law enforcement, the local prosecutor's office, and state police. So at that point in time, our administrative investigation may take a pause because we would not want to get in the way of a criminal investigation. We tape record all of our interviews. We collect all the evidence that we can find to prove or disprove the case, and then we will produce a report. Typically, we like to have a turnaround of somewhere around 30 days for this to happen, but we all know that anything can happen during the course of investigation. It could slow us down, especially if it goes into a criminal realm where we're at the mercy of law enforcement. So, but we do, I do press to have a very thorough but very timely report and investigation.
Do you know of any instance where, say in the instance, and I did not write down the year, so I apologize, where there was one found credible out of 8 allegations? Do you know of any instance where those 7 that were not found credible? Describe to me the process by which they're determined not credible. In other words, what was an example of how it was found to be not credible?
Okay, so the one that was substantiated, the other 7, we have 4 findings that we use in our investigations, and obviously our standard of proof is preponderance of the evidence. So we can substantiate a claim. We also have the possibility of exonerating a claim, which means that generally those would be more applicable in a force situation, because that would mean that inappropriate or excessive force was used, but it was justified based on the circumstances. We also have unfounded, which means that the allegation was just completely false from the beginning. The staff was not there, the youth was not there, video disproves it. And we also have not substantiated, which means that there is insufficient evidence to determine if the allegation occurred or if it didn't occur. So of those 8, 1 was substantiated. The other 7, I can provide you. I don't have that with me today, but I can provide you what the other findings were. So some of those may have been unfounded, meaning the allegation was false to begin with. Some of them may have been not substantiated, meaning we pressed and tried to find any evidence available and still could not collect enough to make what we would call definitive finding, a finding of substantiated or unfounded. So those 7, they could be a breakdown of the other 3 findings, and I don't have that with us today, but we'll be glad to provide that to you all for each of those years if you would like it.
Yes, I would certainly appreciate that, and I just kind of as a comment, I'm glad that you stated in terms of your feelings, which would coincide with mine, that even if we have 1, that's too many.
Yeah.
And I appreciate you getting to the bottom of those.
Yeah.
Thank you, Mr. Chair.
Senator Carroll.
Thank you, Mr. Chairman. And gentlemen, y'all don't have to get into details of these questions. Are all of you, how many of you are there again? And all of you are former law enforcement officers?
Currently, there's 7 people in our office. No, 8, I should say. Ed is the manager. We have 2 supervisors, and we currently have 5 investigators. 2 of those investigators have started within the last 60 days. So for the majority of the year, we've had 3 investigators and 2 supervisors, but myself and DeAndre Davis, the other supervisor, we are basically working supervisors. So
Okay, and all former law enforcement?
all former law enforcement, either state or some have federal law enforcement experience.
Okay, and have any of the staff kept up their certification as law enforcement?
No,
No, sir, we're not POP certified.
we're all non-sworn now.
Okay. And what training do you receive in conducting these investigations other than previous?
Okay,
career?
we take any training that's possibly available to us. We have taken courses at the Department of Criminal Justice Training and dealing with sexual abuse investigations. We do online trainings through the National Institute of Corrections, which offers some investigative classes for sexual abuse and confinement settings. We've sent investigators whenever possible to outside trainings related to sexual abuse and investigations. We attempt to make attempts to go to any training that's available to us. And each of the investigators, when they're hired, there's a standard core of classes that we require they complete so that they are prepared. Because obviously being a police officer is and investigating things in public is much different than conducting investigations in a confinement setting. So we try to train them up in what those expectations are.
Who is directly over the IIB?
I am, sir. What?
And who's above you?
Above me would be Office of Legal Services, which would be Miss Leah Boggs, that I report to directly, and then the Secretary's office.
Okay, so the Secretary, Office of Legal Services, and then you all.
Yes, sir.
Who makes the final decision on whether or not an allegation is founded or unfounded?
We do. Well, I say we. The investigator does. It's reviewed. His report is reviewed for accuracy and whether the finding matches his evidence by our supervisor and myself. So I sign off on that report as well. It then goes to the Office of Legal Services, which they make sure that our findings backed up by evidence. Very rarely is there any question. If there is, there may be a small discussion. That might happen a couple times a year max. It's never been questioned by any secretary I've ever worked for.
Are there ever times when elected officials or political appointees have been involved in this process?
No.
No, sir.
Okay.
Absolutely not.
Thank you, Mr. Chairman.
Senator Thomas.
Mr. Chair, I have 3 questions that I would like to ask.
Go ahead, quickly.
Okay, thank you. First of all, you mentioned that these 6 cases of substantiation over 55 cases that have taken place over a number of years. How many years are we talking about?
I believe those statistics were back to 2015.
Okay, so we're talking about a period of, let's say, 9 years, 2015 to 2023. Again, I want to get a clear definition of what we talk about when we talk about sexual abuse. Are we talking about officers to the children? Are we talking about children to children? What's the definition here? I think it's important to understand what we're talking about.
Okay. With regard to what we are investigating sexual abuse of a staff member abusing a youth. Youth on youth activities are not investigated by our office unless there is some supervision related issue that we identify. So every case that we were talking about earlier is relating directly for a staff allegedly having sexually abused a youth.
You want to read that definition to him?
And I have
I could read the definition to you that by what we go by. A lot of this isn't necessarily physical interaction or touching. Some of it could be grooming. Some of it could be, hey, the staff member has given them their Snapchat or their cell phone number to where they're having conversations outside the facility. That is lumped into the sexual activity because we look at it as grooming. Okay. So,
and just help me out again. And I know you may not have accurate figures, but over the course of this 9-year period from 2015 to 2023, how many staff members have we had come through DJJ? And at the same time, how many offenders, juveniles, have we had come through that period?
I apologize, sir. I don't have those figures, but we could. Part of that figure would come for DJJ because we obviously don't monitor the staffing levels of DJJ. But I could provide you with the number of people that offenders that we have allegedly had over those years.
Just roughly, are we talking about maybe having over this 9-year period, maybe 500 staff members, maybe 5,000 offenders?
What's your definition of offender? Are you talking about?
So someone who's incarcerated,
Okay.
a juvenile who's been
We
incarcerated.
wouldn't have those numbers. That would be a Department of Juvenile Justice would have those.
Okay.
I apologize to you.
Okay. Thank you.
Representative Bowling.
Thank you, Mr. Chair. 2 quick questions. First of all, the Campbell County incident that happened back in May, when did you all first get wind of it, or when was the allegations? When did you all?
Our first hotline call was May the 31st, I believe.
Okay. And when was it reported from you all to the Office of Legal Services?
That it would have been that day.
That day
Yeah.
on May 31st?
Yes.
Okay. Thank you very much.
Yes, sir.
I have one follow-up to that. Regarding the agency's internal hotline, are you saying that the agency's internal hotline did not receive a report until May 31st, or that your office didn't receive notification until May 31st?
So the agency's internal hotline, I think we call it the DJJ hotline, which is the hotline that we directly answer. I don't know of another internal hotline. So there's only the DJJ hotline, and that is our responsibility to monitor.
And did you receive any calls on that hotline responsive to what Representative Bowling just asked?
No, sir.
No, sir.
Until May 31st?
Right.
That's
Correct.
Thank you.
Yes, sir.
Representative Fleming has a question.
Thank you, Mr. Chair. Real quick, do y'all go and look at, investigate any the proper procedures and protocols were followed if there was a misapplication or the spray is injured not only the employee but also the kid?
We've been tasked with reviewing every OC deployment that DJJ utilizes or disperses. So we look at the incident reports, we look at all the documentation, any video evidence that may exist, we review all of those. Yes.
And have you determined that they've been following proper procedures, or have they not? And then you made suggestions to them for them to follow procedures.
I don't have the statistics directly in front of me today, but I can tell you that from my recollection, a large majority of the OC sprays that we reviewed have been unfounded, meaning that there was not excessive force used, so meaning it was a proper application.
Thank you. That's good. Thank you.
See no further questions from the committee. Thank you all for your time. And at this time, we would invite Mr. West and Ms. Hunter up. You're welcome to stick around if you want to, Secretary. Please identify yourself for the record, and then you may proceed at your discretion.
My name is Lauren Beeger Hunter. I am the directing attorney at the Glasgow Trial Office. Previously, I was the directing attorney at the Columbia Trial Office.
My name is Brian Scott West. I'm the Deputy Public Advocate for the Kentucky Department of Public Advocacy. Thank you all for having us today. I want to pull up my PowerPoint if I can here. All right, we're here today to talk about conditions of confinement for youth, particularly at the AYDC, or now the ARJDC. I want to tell first about our statutory authority from which we're proceeding. One is what everybody knows us to be. We represent people who are charged with crimes who can't afford a lawyer. That includes most all juveniles. Most children don't have their own income. And so we have most of those people. Sometimes a parent will hire a lawyer, but most of the time we represent someone. But we also have an oversight duty for someone who is in the custody of the Department of Juvenile Justice, whether we represented them or not. If they are being watched by DJJ, we watch the watchers. That authority came out of a statutory provision that was enacted as a result of a consent decree agreement with the Department of Justice in the mid-90s. I'm going to ask Lauren to start talking about the things that bring us here today, that we are concerned that go to the issues of conditions of confinement.
So first, and I apologize. First, I want to make sure I note non-behavioral isolation is not a term that we have come up with, and it's also via DJJ's own recognition, not a term they use, but it is a term used within the Adair Youth Development Center. Most of my knowledge is with the Adair Youth Development Center. As previously having been the directing attorney of the Columbia Trial Office, there was quite a bit of interaction there, and now that I am in Glasgow, I represent a youth that had been housed there. So when I use this term, DJJ is likely to say this is not a recognized term. However, it is the term formally used with the Adair Youth Development Center.
And let me be clear about that. In an answer to an open records request, there was a statement that we don't know what you mean by non-behavioral isolation, but that is the term that we have seen in our children's files written sometimes as N/B isolation, but sometimes written out completely, non-behavioral isolation. So this is a term that is used by the AYDC.
So the policies that we're going to discuss are actually the policies that they are AYDC's policies and procedures. They do not allow for non-behavioral isolation. Just as a general background, isolation is when a child has been removed from the general population and is in a secured, in this one cell, in which they are not interacting with other youth and they are not doing other things. Via the policies of AYDC, it cannot be used as punishment. It cannot be used for anything other than a major rule violation. It cannot be used as a suicide prevention. It cannot be used as a protective custody measure only if there is a major rule violation, and that is after there have been several procedures that have been followed. So one of the things that in my review of my client's file, in my discussion with other attorneys that are handling, to be candid, one of the riot cases, and talking to former employees, is that isolation was being used as the rule. Children were not being released regardless of staffing. Even when staffing seemed to be better, they were still remaining in their cells 24/7. It was not because of a major rule violation. And I want to also give background. When I say their cells, this is not like a jail setting or a prison setting where there are other individuals in their cells. The cells at the AYDC facility are individual cells. No one else is in those. So I want to make sure I've clarified when I say cells, it's not where there are other children located in that. They are solitary cells. When it was a major rule violation, isolation was the go-to. And I want to
go ahead.
DJJ has several policies regarding isolation and regarding rule violations. They're pretty thorough in all candor. And they specifically discuss that a child that is accused of a major rule violation has to have a due process hearing within 24 hours. That's to be reviewed by a treatment team to determine what is the appropriate sanction for that child. It's supposed to take into account their previous history. What we are finding in these records is there is no due process hearing, and the automatic sanction that is given is isolation. And even when there's not a major rule violation, just children were being brought in and had not had any behavior issues there, they were immediately placed in isolation for weeks and months and not getting regular showers. And I apologize, I'm going to make Scott crazy as I'm a trial attorney, so slides are not necessarily what I do most of the time. So I'm trying to help Scott with the slides. So I want to make sure I've made this clear. Kids are never out. They occasionally get a shower. They occasionally get a phone call. They're not going to school. They're not getting any counseling. They are in this cell all the time.
And what Lauren's talking about at this point is non-behavioral isolation. You didn't do anything to get this. When a child comes to you and says, they put me in isolation and I didn't do anything, and I was there for 12 days, your first reaction, quite frankly, as an adult is, well, that's not what the policy says. There's a limit of 5 days. You have to have done a major violation. There's supposed to be a hearing. There's supposed to be a recommendation. And none of that happened. So are you sure this really happened?
And so what we're finding in these files is it is literally stating non-behavioral isolation. In one case, it's at least 12 days it's noted as non-behavioral isolation. However, I would go as far to say probably 14 is the first 2 days that child was there and undocumented as to what occurred. And the first date that we see a note says continued non-behavioral isolation.
And those things are borne out by our investigation that include more than just talking to our clients.
Yes, the investigation that we have done is our clients' records, reviewing I've been fortunate enough to have some other attorneys be willing to share some of their records because DJJ has denied my open records request for records of some other youth. We have interviewed former employees that work there. I've talked to other attorneys and said, what is this child experiencing?
And all of that was non-behavioral isolation. We also are going to talk about isolation that is due to behaviors.
So as I talked about, the only thing that AYDC's policies and procedures allows isolation for is a major rule violation. So these are, larger things: attempted escape, assault, attempted sexual assault, things of that nature. Even when that is accused to have occurred, as I said, there's that due process hearing where within 24 hours that child is entitled to a hearing amongst a treatment team that allows the child to make a statement to the team as to their account that takes into account the child's previous history, where this child psychologically is. Is this something that they are in need of further counseling because there may be a trauma response or things like that. These are the things they are supposed to be doing. Instead, in AYDC, it was a unilateral decision. There are some checks and balances for isolation. The superintendent of a facility is not authorized to approve isolation beyond 24 hours. And really, every 4 hours, you're supposed to be doing checks whether isolation should continue to occur. And we're not seeing those things. Isolation's going on for days. And even when they're not calling it isolation, it is isolation because they're in these cells that we're not allowed out of. The other thing to know is I keep referring to treatment teams. So that is they're supposed to have a treatment director at each of these facilities. AYDC did not have one. So there is no treatment team that is at AYDC.
Let me stop you right there just for a moment. Senator Neal had a question, I believe. Okay. Yep.
So there's not even a process available to do this due process. Isolation, as I said, the superintendent is not authorized to go beyond 24 hours with their own isolation. There is a checks and balances where they're supposed to be, the supervisors are supposed to then start to approve after, I think, 36 hours. And I apologize, I have that listed. But there's a checks and balance that after you get to a certain amount of time, that goes to the next supervisor and the next supervisor, and it's not supposed to exceed 5 days. And these are their policies, and none of this was occurring. I also think it's important to note, we have done a lot of research about why is isolation so problematic for children. There are scientific studies that show after being in isolation for a prolonged amount of time, the receptors in your brain that regulate aggression and fear no longer are working the way they're supposed to. And when you look at the policies that AYDC has, if they were to be followed, it would take that into account, the science behind that. But they're not being used, they're not being implemented. The other thing to understand about isolation is there was not regular nurse consultations to make sure, how is this child doing? Is there an injury? Is there a psychological problem? They are supposed to still be receiving recreation time, and that was not occurring. They are supposed to still have access to all the things that they're supposed to have in terms of, school and things like that. And these things were not occurring on a regular basis either. And just way background, that is from interviewing former employees, looking at records and things like that. I want to jump in also to the grievance procedure. So they are supposed to have grievance forms pretty readily available to the children. The problem is if you're in isolation, it's not as though you can go walk up and grab a grievance form and look at the procedures regarding that. So the only way youth were able to get grievance forms were banging on the isolation cells to try to get attention and yelling. Well, the problem with that is then they were considered to being disruptive. And so, there was not a lot of motivation to get a grievance form because you could be punished further. And then you were still dependent on the individuals that had housed you in isolation. We know from a statement from the superintendent in an IIB investigation that she noted she wasn't allowing youth access to the hotline calls while they were in isolation. And there was a youth that, until he got out of what they called disciplinary isolation, it was a few days later that he was finally able to make a call to what ended up being a substantiated excessive force claim. There are procedures for incident reports like isolation and use of pepper spray and things like that that must go in an incident report so that it is making its way to IIB if it needs to. Well, the problem was they weren't regularly filling these things out. For instance, in that the situation with the pepper spray that was substantiated, but for that child's phone call that he finally got to make a few days later, it may not have made it to IIB because that's how they received it. In one case, there was an incident of an allegation of excessive force where the superintendent was concerned it was a technique that was not an approved technique because it appeared there was a restraint around the neck area. And it was 2 months after the fact that she reported that. And during that time, that youth was around the individual alleged to have done that. It was a not founded report because some of that restraint happened where there was not a camera. But they also will note in the same report, they talk about a substantial amount of time where the youth is screaming and crying in pain via the notes of the own IIB investigator, who that is his language, not mine. And there seems to be concern by other staff that this force was excessive and went beyond what they were allowed to do. And during that time, that staff member was, don't forget that. In terms of that pepper spray incident that I talked about, that occurred through the isolation door. So it was a steel door and it came through the slot. And that wasn't reported but for the youth a few days later on that hotline call when he was finally able to make that call. And in one of those times, too, that was a hotline call a few days later when that youth finally got to make that call. It was substantiated because he was left to sit in the pepper spray for about 45 minutes. And I want to make sure I've explained pepper spray. I've had the unfortunates of being pepper sprayed once at a jail by accident. I don't want to say that name because I like that jail and it was an accident. But the reason pepper spray is used versus mace, and I want to apologize because I think the document I had said mace, but it is pepper spray, is because pepper spray creates a physical reaction. So if you have an individual with a mental illness or who is drug-induced psychosis or something of that nature, they may not respond to mace because it's more of their psychological response. Well, as science shows on pepper spray, it's a physical response that causes difficulty breathing with the lungs, difficulty with the eyes. So I want to make sure I have covered that pepper spray may not have long-term effects. But in that moment, you literally can't breathe the way you're supposed to because that is how pepper spray is designed to work. And that child had to sit in that cell for 45 minutes before he was allowed to go and shower and to rinse that off. And that child didn't have his room decontaminated in either of those instances. I also wanted to talk about concerns with living conditions. So AYDC policy says that all children are entitled to clean bedding, linen, and clean mattresses. The day before the riot, and I know you all have probably heard some testimony to this, there was a sprinkler break with some of the youth in that pod. And so even the children that were not in the cell that broke the sprinklers, their cells were flooded as well. Later on, and I've just learned this, evidently they thought they were turning the water off, but flooded it again the next day. And those cells weren't dry the day the riot happened. You have heard testimony the reason the door was opened was against policy, but it was because toilet paper could not be put under the door because the floors were still wet. That was 24 hours later that those children were in a place where there was not clean bedding and dry places to sit or lay. Which is against their policies as well. And as I said, some of that, their IIB reports, I have looked at things. It is a hearing you've previously listened to. It is the control room log that substantiates that as well, and then just reports from clients. And then, of course, AYDC has requirements. They have to provide group counseling, individual counseling, family counseling, and things of that, substance abuse treatment, and things of that nature to the children that they house. That's not occurring. We have interviewed treatment directors at other facilities who have said, we know they didn't have somebody there. We wanted to come and help, but we were denied access, even though we were able to go to other facilities, even though that wasn't our primary place. I've heard from individuals that have worked there that said we weren't allowed to bring kids out of the cell to do counseling. They were locked down and we weren't allowed to provide that. And so that is another policy that they are not able to. Each committed child is supposed to have a treatment plan. It's supposed to be updated every 30 days. That's not occurring. That wasn't there then. And just once again, I just want to reiterate, I think I've talked about all the things that are on the slide that have not occurred for the most part. And those are things that by policy they're supposed to be providing.
So the last thing that I want to say is, obviously DPA has attorneys like Lauren who are representing people who are being charged or could be charged, perhaps as an adult, with the events that went on during the riot. And quite frankly, it is not a good defense strategy to start talking about these things prior to trial. We typically play our cards close and we don't do this. But even though Senator Storm offered us yesterday an opportunity to delay this, the reason that we're coming forward with this now is in part because of the July 14 review of the centers that was published by the LRC. And please understand, Representative Bowling, Senator Storm, I'm not criticizing LRC for not talking with us before the review was published or put on the website. In the acknowledgments, most of the stuff came from the cabinet, Justice Cabinet, and from DJJ. And therefore, there are conclusions in there that don't have the benefit of our investigations. And there's probably good reasons why we were not included. And I'm not faulting the cabinet. I'm not faulting DJJ. I'm not faulting LRC for us not being there. But when you look at what is purported to be the causes, there's incomplete information there. You're talking about days of isolation that led up to this, weeks, 21 days in some instances of isolation, non-behavioral isolation. You're talking about a situation where there's no regular mental counseling. It creates a crucible that...
And I want to reiterate, the American Medical Association, the American Pediatric Society of Psychiatry, and even DJJ, because their policies reflect the science, acknowledge how damaging isolation is, particularly on children where their brains that monitor impulse control and things like that are not fully developed. There is science that says it creates psychosis, paranoia, depression, self-harming behavior, suicide, and DJJ, I think, has recognized this at one point because their policies were created in 2022. And if their policies are to be followed, it's a recognition of the science as to why this is a danger.
That concludes our presentation. We're available for any questions.
Senator Neal.
Thank you, Mr. Chairman. Perhaps you could give me a little flexibility here.
Sure.
Thank you, sir. So the items that you're raising here are going toward a subject to a process of litigation?
No, I'm going to be very candid with, this is not my forum. I'm a trial attorney. I cannot express how hesitant I was to come forward. This is not my arena.
Okay, so that's all I wanted to know on that.
Yeah.
So that opens the door for other questions I have.
We have not sued and are not here today threatening suit.
If I'm honest, sir, this may sound crazy. You may think I'm absurd. I'm a Christian woman. And if I follow my faith, I cannot be silent when these policies are not being followed.
Let me stop you here because I'm not really heading in that direction.
Okay.
I trust that you're here with the best intentions and that you do your job professionally, and you're here purposefully to do the best that you can as you're led by who you are and what you do. So I take that as a given. Okay. But what I'm really trying to get at is whether I'm asking an appropriate question.
Okay.
Because I'm trying to understand what the situation is here between you and DJJ and whether this is an adversarial piece or not, so I can get to my real question. And I think you've answered that.
Okay.
Maybe in this litigious world. What I'm trying to find out is these are facts, are, as you say, verified facts that have been submitted to DJJ. Is that correct?
I have not. So, first of all of the records I have are DJJ records.
But my question is, have you identified some process or utilized some process, a means of communication of some sort of way from where you're perceiving these? Because you have a collection of violations here, which may not be perceived the same way in day-to-day, what you do in these situations, because it can get very complex in these facilities. I'm just trying to find out whether or not this information is getting to DJJ, and what I'm really trying to find out, if so, is there a process by which there's been a response to address these issues, and what was that response? That's really what I'm trying to get to.
Okay. So, for years, there was a monthly or so meeting between DPA and DJJ that has lasted several commissioners back. It's goes through several governors, several commissioners, where about once a month at a DJJ venue, at a meeting that's pretty much initiated by DPA, there would be this type of discussion. Those quit occurring a few months ago, maybe more than a few months. My understanding is why they quit occurring is because at the time, DPA's side of the table thought that this was not working. We were not being heard. People did not agree with what we were saying. And in fact, they said that it became no longer an issue to do it. And that's what I have been told as to why those quit occurring. Now, at my level, the reason that we are kind of doing this today is because we're trying to catch up with what has already been put in the report to try to get our minority report into what's going on, specific regard to causes of the November 22 riot.
Okay. Mr. Chairman, I guess really my questions, given the responses, are really to DJJ. So I'll stop at this point, unless they're going to be called back up.
Representative Burke.
Thank you, Mr. Chairman, and thank you all for bringing this information to this committee. Has DPA done any investigation into whether or not similar conditions exist in other youth detention centers?
That I can't answer today. I do know that Laura Karam, who is our juvenile post-disposition branch manager, has looked at conditions in other places, and usually she would be the one that would testify as to those other things. This was brought to my specific attention by Ms. Hunter because of the cases that she and others have that are arising out of AYDC.
And I can say my client is currently in Fayette County. I know this isolation is not occurring. I have some of his records there if that helps. That's kind of, I'm a trial attorney, so my familiarity with the facilities is dependent on, do I have a client there that I'm working with? So I will say there was a stark contrast in records between what I saw in Fayette versus Adair, and that was kind of what brought my team to being concerned.
And let me also say that my role as deputy, a lot of it is legislative work. Initially, when Ms. Hunter came to me and told me this stuff, my first reaction was take it to the Judiciary Committee because they usually do legislation involving this type of stuff. And Senator Westerfield has a reputation for taking juvenile bills that are good juvenile bills and getting them through. And it was at his suggestion that we are here, because once we showed him what we had, he's like, I can't not do something with this. And so that's how we kind of got into this room. But the goal was not an adversarial role so much as it was we wanted something that would end isolation, except under the circumstances which the policy purports that they occur.
Absolutely. May I ask a follow-up question?
Sure.
Attorney Hunter, in your experience as a trial attorney, I'm sure you've been to multiple facilities across the state to meet your clients. Did you find that the Adair Youth Facility particularly was designed structurally in a way that is different than other facilities you've been into, that perhaps is part of why this is occurring in this facility to this extent?
So one thing to know the difference when I go to a juvenile facility versus an adult facility, I see tremendously more of an adult facility. I've seen lots of the insides of jails and things like that. I will tell you, having been in parts of Fayette detention facility versus parts of AYDC, they look very different. Fayette looks at times like a school, but of course a lockdown school, if that makes sense. There are classrooms and things like that. I've not been able to see more than what I've seen on surveillance video of Adair, but still it looks starkly different, if that makes sense. In terms of Fayette, my understanding from talking to staff there has a similar structure in terms of the cells within the pod. I don't know if anybody here has ever toured a youth development center, but what it is there is a row of cells, and then there is a community common area. My understanding, Fayette, what they do is they alternate 30 minutes at a time from what my client has told me in terms of being out of their cell to ensure they're getting out, socializing, rec time, school time, things like that. That does not happen at Adair. So I will say, my understanding is the same type of structure in terms of pods is pretty similar at Fayette versus Adair. It's just the letting the children out.
Okay, thank you for that. I would just like to make a comment.
Okay.
This information is incredibly distressing for many reasons. Research on adults in solitary confinement says that people who experience that when they're incarcerated experience drastic increases in their suicidality for the first year that they're out, 78% increase in suicidality. You're much more likely to die when you come out of a facility where you've experienced that. So I'm deeply troubled by this information. I hope that the working group that's been working on DJJ issues will be able to take this up, that we don't lose sight of this, because children's lives are on the line, and we owe them a duty of care if we are taking them out of our communities. And so I appreciate your testimony today. I want you to have my assurance that this is something that I will put my efforts into and support all the people who are on that working group as they try and do bipartisan solutions to these kinds of problems. Thank you.
Thank you.
Vice Chair Howell.
Thank you, Mr. Chairman. It's much of a comment as a question. Ms. Hunter, appreciate you driving up today to be with us. And Scott, it's always good to see you here. Appreciate all of your time that you guys and everybody else with DPA put into this. I know it's somewhat outside of your realm a little bit of normal everyday demands, which are excessive in some points. But I think it's absolutely crucial that we get a different view on this and a different viewpoint that it isn't part of what apparently was set forth in some of the other investigative materials. It's really important for all of us to be able to have this view, and I know it took a lot of time and effort, but I just wanted to tell you how much I appreciate it as a member of this committee, and I look forward to digging into this more as we work through this process, and I really do appreciate your time doing this.
Thank you.
Thank you, Senator Howe.
Seeing no further questions for you all, Secretary Harvey, would you all want to come back up and address anything that was raised?
Well, I suspect the commissioner will have more details about isolation policies and that sort of thing. I guess I would start by saying I mean, no reasonable person would think it's fair to expect us to address what you just heard because we've never seen it before. I don't know how long the committees had this presentation. I don't know when DPA prepared it. But I don't know how to respond to some unnamed employee told one of our staff members this. So, I mean, I don't know that there's a way that we can respond to all these specifics because we had no notice of this presentation. There were a couple things that were brought up. I will say that I have a monthly meeting with the public advocate. I have implored the public advocate over and over that if you have issues with DJJ, let's talk about it. Let's sit down. Let's try to solve them. And what I've said to him more than once is that we should not be adversaries. We're not the people prosecuting your clients. You know, that's the Commonwealth of Kentucky. What I've said is if there are issues, we should be collaborating to try to solve these problems. Now, that invitation is rarely accepted, but I still believe that that is the case. I think that we should sit down with DPA, we should work through these issues, and again, I have monthly meetings with the public advocate. I can assure you that he has never addressed one word of any of this that you've heard here today. That doesn't mean that it's not valid. I have no way to respond to all these specifics, but what I would say is that we are ready and willing to have a collaborative, productive partnership to address these issues. But that takes that's got to be a two-way street. And as I say, have a monthly meeting with the public advocate. Have never heard one word of what we've heard here today. In terms of isolation, I don't think nobody's going to argue that isolation is a good thing. And I don't know what happens hour by hour in a detention facility. I do know that in Adair County, around the time that we had this riot, yes, there were lockdowns, there was isolation. The juveniles we had in Adair County, we had some very, very dangerous people. As I recall, it was well known in that facility that there were certain members of the population there that were planning to cause extreme violence. And I would say, again, nobody wants any youth or anybody to be isolated. But if that's what you have to do to try to preserve safety, I mean, what else can you do? And so I think that the first order of business is to try to keep people safe. And I believe, and we have Mr. Sweat and Mr. Chandler here who are in these facilities all the time. If you would like for them to talk about the current conditions at the Adair Detention Facility, I think they would be happy to do that. But I've got to say, there's no way, and I don't think, again, no fair-minded person could expect us to give a point-by-point response to a 15 or 20 slide presentation that we've never seen before. But I'll say again, and I'll say this publicly, I'll invite my friend, the public advocate, again, to collaborate with us on these issues. And we will work through these issues, and we will try to find common ground. We'll try to find solutions. And I would also say, if you go back to the time of the disturbance at Adair County, I know we've covered this ground often, but it has to be said again. We simply did not have the staff to run that facility. Now, that was well known at least as early as 2017. It was published that staffing was dangerously low, and that the reason that staffing was dangerously low was because of inadequate compensation. And it went unaddressed for year after year after year until we started to address it. And so we're building that up now, and I think if you talk to the gentleman in charge of these facilities about the conditions that we have today, you would get quite a different picture. Commissioner, do you want to talk about isolation policies and what sometimes is required by real-world considerations?
I can do that. And one thing I want to address before that, though, is I have met monthly since I began with DPA, with Laura Karam and Tim Arnold. All of our meetings were very productive, very cooperative. Just recently, they quit contacting us to set them up, and I presume because one of our discussions that we'd had was how short-staffed they were, and felt like that maybe they were busy with other things, and we certainly were with trying to get a lot of other things done, but I had kind of wondered where they had gone to, but none of these were ever specifically addressed, and anything they ever brought up, I was prompt to, and I'm very surprised to hear that information given, because that's certainly not my understanding at all. There are very specific policies on isolation, and I think Secretary knows on this that nobody hates isolation more than me, and I have probably been his ear many a time on that. I'm certainly, as an advocate for kids for many decades, know all of the information about that. I hate that. But and again, I do not think these are current conditions. I don't know the time period that they're talking about on that. But I do know that there was a period when we literally had 3 and 4 people in the building, and very dangerous kids, primarily gang-involved youth from Jefferson County, that you literally, you have to gauge, as much as I hate having youth in their cells, and you can call it isolation generally is when youth goes to an isolation area. We have isolation 3 or 4 cells in a facility. The reason kids have individual cells is certainly not anything for punishment, but that's a PREA and an ACA. We know that kids, for their own safety, do best. We don't want to double bunk. There's a lot of material on that. So when you have to do a unit lockdown or a facility lockdown, then the kids are going to be in an individual cell. And again, that's for safety. So you have to judge what's worse, that kids are locked in their rooms longer than we want them to be, or that kids are fighting and assaulting staff and trying to tear up the facility. And until we could get adequately staffed, we had to deal with those issues. And we tried to do as best we could on that. When the teachers would go down to give work, we have an institutional rec leader who would try to go down and do things. I would dispute on some of that. Kids were getting out for showers for the most part, getting their phone call. We realized that for that period of time, it was a very difficult area. And I will also say that we did our best to pull in anybody and everybody from DJJ. So if there's somebody who wanted to come from DJJ, I'd like to know that, because we were begging and stealing people from all of our other facilities. Would you please come in? We had community worker come in to do some treatment with our youth. We've looked at private contracting because we were unable to hire some treatment programming folks. I think we've climbed a long, long way up the hill since then. I have recently done a poll of all of our facilities to ask what they're doing on what we call movement. And that's when the kids are able to go to the dining room, they're able to go to the gym, they're able to go to the outside rec area, and so forth. And everybody is moving now. Some of them do a little bit of difference. You mentioned one with Fayette. They have something they call sometimes half in, half out. And sometimes you have to do that with the kids because if you get too many of them in one area, again, our biggest issue with kids is gang involved. And we may have a unit where you do have to lock down that entire unit. And I'll give you some of the issues that we've dealt with. We may have kids in the same facility where one guy's brother shot another guy's brother to death. And there's a target on that kid. And we know that they are all trying to get them. And they have all made the very expressed threats that that kid's going down. So sometimes we don't call that isolation, because isolation, as we do call it, is a behavioral. Somebody does something, he tries to punch somebody, somebody's tearing up something, then we do have very specific. It is 4 hours limited for that, and it requires the authorization from the superintendent, the administrative duty officer, the treatment director, or shift supervisor. Any extension of that time requires the superintendent approval and is limited to 24 hours. Beyond 24 hours requires higher level of approval than that, and over 36 goes all the way up to our chief psychiatrist, our director of mental health services. And youth are still to get services, including education and counseling and so forth, while they are in isolation. And again, when I talk about isolation, it is in isolation cells. And part of that is because oftentimes those youth might be, exhibiting suicidal or other behaviors at the same time, or become that when they get in there, is because those cells are under complete video surveillance. There's a little black square at the bathroom, at the toilet. But other than that, our staff in the control room can see into those kids in isolation. So isolation is from us different than you would have a unit lockdown, a facility lockdown. And again, I want our kids out. I want them to go into the dining room for everything. I want them to go get in their 1 hour of recreation in the gym as part of their school day with PE, and another hour as part of what we're mandated with our large physical exercise. We're putting as much programming. We've got a therapeutic arts program going at Fayette, and it's going into Warren, beginning there. We're looking at a positive-based support system training and doing with our staff. So we're trying to get there, but I will admit there were some dark days in some of those times. But I'm certainly, like I said, I hate having kids in the room. I'd go to bed not sleeping that night thinking about some kids are in their room and not being able to get out when I want them to. But safety and security comes first, and I believe we would have some very serious incidents if we would have had to have complete free movement when we didn't have enough staff to barely get, the basics done.
And I would say we also had situations in Adair County at that time where we had children. We've talked about this before. I know we're covering a lot of old ground, but this is, you ask us to. We had children in Adair County who were kept isolated for long periods of time because they had severe mental illness, untreated mental illness, and because of their mental illness, anytime they were outside of their cell, they were violent, they were dangerous to other children, they were dangerous to staff. These detention centers are not psychiatric hospitals. A child like that, I've said this a dozen times over here, a child like that should never be in detention. And I'll tell you this, the Department of Juvenile Justice advocated for that child as much as any lawyer to try to get that child in a proper facility. And it didn't work because private facilities won't take children like that. So yes, that's an example that I know of where we had a juvenile who was in isolation, I'm sure beyond the policy, because in the real world that most of us have to live in, there was no other choice.
We have a question from Representative Lockett, and then Senator Carroll will finish this up.
Thank you, Mr. Chairman. I just have a couple of questions. The first one, we heard testimony prior that children are or were being placed in isolation on a regular basis for days upon coming into the facility. Is it your testimony that you are or you are not aware of that happening?
That's not currently happening. Now, it may have happened some back from there. And again, it's the difference. They weren't being placed on isolation. It was that there was no movement in the facility. So, you can potato. They were going to their room and not being able to move to all the places we wanted to, but they were not going to isolation. They were not considered an isolation status. It was just simply that we didn't have enough staff to be able to move youth to where we need them to move. So they went to their cell. And so they were like, there's like pods where they're like 10 cells and then a day room. And so the kids are in the pod, in their cells. Staff are in there, they're not being completely left, the staff are rotating. We have to do wellness checks every 15 minutes. And there's a probe thing that we have to prove that they've done those checks. So they were not like just locked away and all by themselves. And like I said, the teachers would come down, other staff would come, but there was not movement in the facility like you would expect and would want.
My second question is, currently when a child is placed in isolation, 100% of the time, is there a hearing for that child?
No, because generally most of the kids come out in 4 hours. The vast majority of youth that go into isolation are out in 4 hours. Usually, the point of isolation when we're using it behaviorally is it's not to punish the kid. It's not you did this, so now you've got to go. It is only that they're supposed to go in until they can regain control. And so if they regain control in 2 hours, they need to come out. If they regain in 35 minutes and they're calm and fine, they need to come out. It's when you have a youth that goes into isolation for 4 hours and you still talking to them and you're still saying, I'm going to get that blah, 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 and I'm whatever, and is banging on things and whatever and threatening, then you have to look to extending it. So some of those youth would, but the majority of the kids, once they go in, they do calm down. And we do try to have, and again, when we have the right numbers of staff and we have counselors, we can have the counselor go down and talk to them and say, what's got you upset? And it may be not even anything with the facility. It may be they got a very disturbing phone call from home, and that's what set them off, and that somebody talking to them about that issue. So when we have counselors in our facilities the way we want, a lot of those behavioral things are nipped in the bud pretty quick.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. And I do want to just comment at the beginning that these issues did come up during the working group. There was testimony related to isolation. The one young lady that in particular, there were numerous discussions over that. So this is not something new. It was discussed. And I also want to make sure everyone knows that there is another external group that will be coming in to do a review of DJJ as part of Senate Bill 162. So that there are more actions that will be taking place. My question first has to do with policies. Obviously, policies did not keep up with the evolution of what was going on in DJJ, the more violent population, the changes in Senator Westerfield's bill. Where are the policies now in dealing with this specific issue with isolation? And I'm not saying we change policies to make bad things good, but again, it's a different population, and I think as a Commonwealth, we're taking a little bit different approach to how we are housing these youth simply because they are a more violent population, and I don't know that there's anyone that disputes that as being a fact. How are you all looking at policies? Do you have a specific section that is going through policies? And I've looked at the policy manual many times. Whoever built that, they did an excellent job. But I've been around long enough to know that a policy manual is a document that evolves as expectations change, laws change, all of those things. So where are we now with that?
We've done a lot of changing with our policy, and a lot of the regulations are in the process. We've developed specific policies for OC, for the CERT team, for many of the other upgrades that you've talked. We have not changed on the policy on isolation because, again, we're well aware of the mental health aspect with youth, and that 4 hours is gold standard. It's JDAI, it's ACA, everybody else, 4 hours is what the expectation. So we're not looking at changing that. I think some of the things go back to one of the things on the documentation that's important, and maybe that's not a term, the non-behavioral, but we wanted to be able to track when kids were in their rooms and not moving, not specific to anything they had done. And so we have places on our ongoing sheets in the detention center to do that. And I'll give you an example. We had one facility, it was better staffed than some, but still not great. And if they had a police car pull up with 4 kids for intake, they had not enough staff to safely process those 4 kids in. So the kids went down on lockdown so that we could free up staff to go do the intakes. So we make them document that, and they write it in the report. This is why we did it. And we want that so that we can track, so that I can say, because it is so important to me, I want to know how much movement. Why weren't the kids moving on August 12th? Why weren't the kids moving, whatever? And that we have the reasons for that there. So that's not so much change of policy as procedure and just the whole issue of getting adequately staffed, because when we're adequately staffed, kids are out and engaged, and we know when kids are engaged in doing things that their behavior is going to be better, staff are going to feel better. So that's very important we do that. So I'm not looking at changing our isolation so that we can isolate kids more. I want kids out of their cells as much as possible. In the perfect world, they go in there to sleep. They go in there for their hygiene break, because one of the things I saw was saying something about saying our kids kids were forced to urinate and defecate in their cell. Well, that's where they're supposed to do that. Our cells are wet. There's toilets in all of them, and they get hygiene breaks to go in there for that purpose. And other just short times where perhaps they need a little just break from the stimulation of what's going on in the building. But they need to be in school. They need to be in rec. They need to be getting programming. They need to getting their counseling. And that's the way we want to talk.
But I want to say one thing that's been reported to me that has improved. I'm no expert on any of this, but this is what I'm told by our detention people, that after, of course, and again, nobody's going to say that we didn't have really bad circumstances around the problems last November in Adair County. We can talk all afternoon about the events that led to that, because it goes back years, but those were bad circumstances. I've been told by our folks that once the decision was made and the governor issued orders that separated the kids who were charged with the most serious offenses, the most likely to be involved with gangs, the kids charged with murder and violent crimes were separated from the kids who were not charged with such serious crimes, that actually had a very salutary effect on those lower level kids, because what was happening in a place like Adair County, when all these bad things happened, I mean, it was terrible. You had a bunch of kids in there who just wanted to do better, who were trying to behave and trying to do better and trying to take advantage of the programming, but they were thrown in with a group of kids that were hyperviolent, who were organized, and who had a determination that they articulated very specifically to hurt people. And so these kids that were lower level kids that were just trying to do better, suffered some of these consequences that were very unfortunate. I'm told that once they were separated, that situation improved dramatically, and I'm glad that Senate Bill 162 will require that separation to continue. I would just say that putting all these kids together was the way the system was set up 25 or 30 years ago, and it had been that way from the inception of the system until a little less than a year ago. But I think that there's demonstrated improvement there.
And just quickly, I don't know that I agree. If you're going to allow exceptions to a policy, then the policy needs to give you the authority or spell out what exceptions are. Otherwise, the policy is being violated. Period. So I would recommend you add exceptions that perhaps are valid exceptions to the policy rather than just tracking when it's happening. One other question, and I'll stop, Mr. Chairman, just quickly. With the changes coming to Campbell County, with males being added back in per Senate Bill 162, what are the changes within that facility that will provide a safe environment as required by the law now?
I don't want to belabor this, Senator. I will say I agree with you about what your point about the policies. You have to adhere to the policies, and if the practice can't follow the policy, one or the other has to change. But I think Mr. Sweat could give you a complete answer to that, and would you allow him to come up and answer that question?
That's fine.
Okay.
Could you repeat the question?
Senate Bill 162 required that there be a separation within facilities, male, female, violent, nonviolent. How is this going to be accomplished in the Campbell facility, since we are going to be introducing males back into the population that is all female at this point?
For one thing, Campbell County won't have females. It's going to be all male.
It is?
Yes.
Okay, I understood that females were going to be there also.
No.
Okay, my mistake. Okay, that's all I have. Sorry.
Seeing no further questions of anybody on the committee or any further comments from the presenters, this portion of the agenda will be concluded. We did have an individual sign up to speak that's not on the agenda, Donald Peters. And Mr. Peters, as you can see, it's a little bit lengthy. It's now 3:12. Maybe 4 or 5 minutes, if you could, just summarize. And this is only for informational purposes only. We weren't prepared for this topic to come before this committee today, but you drove up here from where?
I think we can get what's needed said in that time.
Hit your microphone. Where did you drive up from?
The Western Kentucky, Owensboro. Okay, I got it now. Western Kentucky, just west of Owensboro.
Okay, please introduce yourself and you can proceed.
Okay. My name is Donald Peters. I was elected 8 years ago by our community. Our community consists of 15 families, and located in that community is probably the largest privately owned concentrated animal feeding operation in the state. It's capable of holding anywhere between 186 and 247,000 hogs. They are located in 6 different concentrated animal farms. And what I'd like to do now is introduce or address the participants in the problem that we're having. First of all, my community. We were elected, Mr. Murphy, who's sitting back there, and myself, to represent our community when the state approved, the Division of Water, approved building a 780,000 gallon hog waste lagoon only 575 feet from my neighbor's residence. The regulations state 1,500 feet minimum. We were not able to even get a meeting with the director of the DOW who authorized this at the time. And not only was that facility built that close to a home, it was built in the wetlands, it was built in the floodplain, and the owner misrepresented the facility he was going to build and where he was going to build it. The Corps of Engineers was called in because he destroyed wetlands when he built it, and they labeled him a willful and flagrant violator. But let's just step back a minute and talk about our community. Among our community are several farmers who've been impacted by these hog operations as well, because they're located in the same area, just west of Owensboro in Curdsville, Mount St. Joseph. The third party outside of CAAPAD, which is Community Against Pig Pollution and Disease, a 501(c), is the Kentucky Energy and Environmental Cabinet, and in particular the Department of Environmental Protection. Apparently, they visualize oversight as being once every 3 years you have an inspection. And the inspections conducted with this operator were you come, you look, you don't count hogs, you don't take any samples of the water or the soil, and you ask the owner just what is his situation, and he tells you, and then you copy that information down and you put it in a report. Now, let me give you a little bit about my background, because I know something about oversight. I retired from ExxonMobil as a project manager responsible for engineering, design, construction, permitting, and startup of oil and gas facilities. These facilities were valued in the hundreds of millions of dollars. And I participated in oversight, meaning that you look for where you're going to have problems and then you monitor those. The state of Kentucky does not monitor anything with reference to these hog operations. Now, the EEC and the Department of Environmental Protection have responsibilities for industrial facilities as well as agriculture. But agriculture is not being handled in the same manner as they do with heavy industry. I'm going to speak a little further about my own background. Prior to that, I graduated from the Naval Academy. I served 11 years as an officer. I was qualified in submarines and was recommended for command of submarines. I know a little bit about oversight because your lives depend upon it every time you dive the boat, every time you leave the dock. What I find a problem here is that the actions or lack thereof of the EEC has contributed to damage to our community. As an example, when I purchased my home, built it 10 years ago, it was valued at $300,000. It's now is assessed by the property valuation administrator in Davies County at $110,000. The same applies to most of the residents in our community which are in the vicinity of these hog operations. 67% devaluation of our properties. What we are asking for is an opportunity to go into more detail, but I want to make one important point. The state has chosen, meaning the EEC has chosen, to classify these hog operations, these CAFOs, as small to medium operations. Therefore, the regulations which they are that they're required to follow, the permit owners, are state regulations. However, with medium to large CAFOs, and I think you could call a CAFO that has 14 barns large versus what in Iowa or South Carolina have 3 or 4 barns as being large, that the state has mislabeled these operations as small CAFOs, and as a result, they apply to state laws apply or regulations applied on state level, not federal. Being that these operations are really large CAFOs, there's a whole set of regulations which require NPDES permits, which are permits that are much stricter than the no discharge permits that the state has issued to these operations. So what we've encountered is a reluctance on the part of the state to do their job, if I may put it that way. They're not protecting the environment, they're not protecting our community, and in fact, they've taken steps to not know about what's going on. We've been recently engulfed in clouds of hydrogen sulfide gas emitted from these CAFOs, engulfing our homes for as much as an hour and a half, in one case 3 hours, 9 times the state standard level. The state at one time, at our request in 2019, put 24-hour hydrogen sulfide monitors in the field. They immediately resulted in violations being noted. After the inspection was printed in November 2020, they withdrew them. Out of the last 8 years, they have had those instrumentation packages in the field only 8 months. That is not oversight, that's not monitoring. And so what we're here to do is request your help in finding a manner, a way in which to get the state to do its job. And that's where we're at now. There's much more information that will substantiate this. For instance, their lagoons are not big enough to handle the number of hogs that are at each of these CAFOs. We can prove that. We've done our own study. Let me just give you another information about Mr. Murphy so you'll understand that we can speak with some authority on this, and then I'll stop. Mr. Murphy has 44 plus years experience as a licensed Kentucky water treatment plant operator, wastewater treatment plant operator, He is presently licensed as well as a microbiologist and water sampler. And we have been doing the job of the state by sampling the waters for the last 8 years, paying for it out of our own pockets, and we can't get the state to use the data. They don't even have a boat to put on the Green River where all of these farms are located and where they discharge. As I said, they don't have hydrogen sulfide packages out there. And what they did when we started calling in using our Mark I noses to register that there is a hydrogen sulfide cloud around our home, rather than calling the 24-hour call center that they share with the Kentucky Emergency Management Agency, they gave us a phone number to call in January of this year. It was an unmanned office, and they wanted us to report to an unmanned office. So there are many more details to go into that we'd like to share with you, and we appreciate this opportunity to have at least identified the problem. But with that, I'll stop. If you have any questions, I'll try and answer those.
Well, it wasn't technically on the agenda, but you did drive up from Owensboro and you're a vet, so we appreciate your service, and our veterans, so we do appreciate your service. And at this time, again, it was only for informational purposes. Thank you for bringing this issue up, and at this point, I'll entertain a motion to adjourn.
Okay, now I have written emails to all of the members of this committee, and I've identified the information that I've just shortened and providing it to you. And those, if you have any questions about the details that are located in those emails, I'd be appreciative of a response, and I'll try and answer them. But our request is that you formally look at this problem and see if we can come up with a solution to exercise oversight, which means monitoring, not an inspection every 3 years, of these facilities and of the operations that the EEC is involved in.
I think Senator Carroll had a comment.
Yeah, sir, I would recommend just to kick off the process, you meet with your local legislators and let them put together a letter to send to the cabinet and let the cabinet respond, and then that would give some grounds to know which direction to head this issue in. So there's something more formal from them to give us some direction. Who are your legislators?
Say again?
Who are your legislators? Your senator, your representative?
Senator Rick, help me.
Okay.
Did you get that?
Yes.
Prior to that, our senator was Mr. Matt Caslin. And Mr. Matt Caslin introduced a legislative amendment which would have neutered the present environmental laws. Forcibly, Kentucky Resource Council, Mr. Fitzgerald, was helpful in defeating that, but at the same time, the amendment was to a proposal to supply funding for protection and inspection of the state's water supplies. That failed. And so we are in a position where our fiscal court and where our representatives are more in tune with the owner of the hog facilities than they are with the community in which those hog facilities are located.
Okay. I would recommend meeting with Senator Boswell and let him become intimate with these details, and that way there would be someone to push issue forward.
Yes.
Okay. Thank you, sir.
But what we're looking for is, I think, a body that has perhaps more authority. We'd be more than happy to do that. And as I said, this is going on for 8 years. I'm 87, almost 88. I don't have too many more days on this earth. And I do not like the idea of leaving a house that I cannot sell. And most of our community is in that same boat. And that is the fault of the government who's responsible for exercising oversight and controlling these operations. And they're not doing it.
We'll stand adjourned. Thank you.
Thank you very much. I appreciate your time.